Good morning, everyone. I want to thank you all for joining us for this webinar this morning. We're going to talk about pot, and specifically, we're going to talk about cannabis disputes in the cannabis space, the types of disputes that we've seen arise, and strategies for avoiding litigation and minimizing your litigation risk. Next slide, please, Margaret. Go ahead, Cynthia.
Okay, great. And just a brief introduction. My name is Cynthia Castillo. I am a senior associate here at Farella, and I practice in business litigation and have been doing work with some cannabis clients. So we will talk about a few different types of disputes and issues we've seen arise in the cannabis context. I'll start off by talking about cannabis class actions, and in particular TCPA class actions and privacy issues in class actions. Tony will then talk about issues about whether cannabis contracts are enforceable, and partnership and investor disputes. And then I will talk about unfair competition claims. Then, if we have time, we will take questions and have a brief breakout room discussion. Thank you. Next slide. Okay, so cannabis class actions. As you can see, this slide shows a screenshot from a website called topclassactions.com, where they are actively soliciting plaintiffs to pursue class action cases against cannabis companies. And this investigation is specific to TCPA violations, which I will talk about during this presentation. Next slide. So the TCPA, for those of you who aren't familiar with it, is the Telephone Consumer Protection Act. It was passed in 1991, and it bans calls made with an automatic telephone dialing system. Under the Act, text messages are calls, and there's currently a circuit split on the issue of what technology qualifies as an ATDS. When the Act was passed, the technology that was being used by telemarketers were these things that would generate random numbers, and so you would get telemarketers calling, just random numbers. And so the ATDS defines, or the Act defines an ATDS as something with the ability to generate random or sequential numbers. But there is a lot of uncertainty about how the statutory definition is applied, and it's written poorly. So in the Ninth Circuit has actually interpreted an ATDS as any equipment with the ability to generate random or sequential telephone numbers, or to store numbers that are to be dialed. So that means that any technology that stores numbers and then allows you to dial them, such as a smartphone, could be an ATDS in the Ninth Circuit. The TCPA is a strict liability statute, and there are few available defenses other than that the business obtained the express written consent of an individual to text message them or to call them. Statutory damages are significant. You can pay $500 to $1,500 per text message. The $1,500 fine is for text messages that were willfully or knowingly sent in violation of the law. Last year, in May 2019, a jury awarded a $925 million verdict against a company that sent over 1.85 million calls. And I believe the court didn't even treble the damages there because they found that the violation was not willful. So you can get into serious trouble here. Last year, Ease Solutions, which is an application that allows individuals to order cannabis through their phones, that app was sued under the TCPA. And they attempted to reach a settlement with the plaintiffs and initially settled for $1.75 million, which would have equated to $25 per text message for members of the class. And the court denied the settlement, said that wasn't enough money. They came back and offered $50 per text message, and the court again denied the settlement and sent them back to negotiate or to go to trial. And that case is still pending. Next slide. One thing about TCPA class actions that plaintiffs' lawyers love is that they're very easy to file. You don't need a lot of facts before you file a case. You just need to know that somebody received a text message and that they claim they didn't consent to it. Plaintiffs' counsel often use form complaints, and as demonstrated by this screenshot here, where a text message was received on December 12th and on December 14th, 2019. The complaint was filed 3 days after the second text message was sent on December 17th, 2019. So you can find yourself in trouble pretty quickly. Next slide. And these are some headlines from Law 360 from the past 6 months, 5 or 6 months. Every few weeks there has been another business operating in the cannabis industry that is targeted by these suits. And the cannabis industry may be uniquely vulnerable to these types of claims because they rely heavily on text messages for marketing. Because they don't have the same ability to advertise, say, on billboards or on TV that other businesses do because of the nature of their services. Next slide. So while the potential liability is significant, you can put in practices in place to avoid TCPA lawsuits. One thing I want you to know is if you send text messages as part of your business, you are engaging in a high-risk activity. There's significant liability that could follow if you don't strictly adhere to the law. So I would recommend, if this is part of your business, that you develop a TCPA compliance program in consultation with an attorney who's experienced in this area. You investigate how you obtained your list of marketing contacts. If you have a list of individuals that you're already contacting, go back and double check and make sure that you obtained express written consent from those individuals and that you have records to show it. You want to have a system where an individual is clicking a box or signing a digital signature to indicate that they have consented to receive text messages. Another tip would be to include arbitration and class waiver provisions in your terms and conditions and link those in a place, right next to the disclosure where the person is signing up for text messages. I would also talk to an attorney to make sure that your terms and conditions are enforceable because that's an issue that courts often decide whether terms and conditions are actually enforceable against a consumer. You should allow consumers to opt out of receiving messages by having something that says they can text stop if necessary. And finally, if you are outsourcing your text message marketing to a third party, make sure that you're asking questions to that third party because you could be liable for text messages they send on your behalf. Next slide. So finally, and briefly, if you do find yourself a party to a class action lawsuit, know that plaintiffs usually ask for the identities of putative class members so that they can reach out and discover facts relevant to their lawsuit. Typically, that's okay in normal class actions. If you sue Walmart, saying that they overcharged for X item, they might ask for all people who have purchased this item at Walmart. In this case, if you are asked by plaintiffs for individuals who have frequented a cannabis dispensary or who have used a particular cannabis product or service, then that could potentially invade the privacy rights of your customers. Just the fact that they are your customer could show that they have used cannabis, which is still a federal crime. So this issue recently came up in a TCPA lawsuit. Spring Big, which is a cannabis marketing company, was subpoenaed and asked for information about the identities of individuals who were sent text messages by a particular cannabis dispensary. They filed a motion to quash, although this issue hasn't been heard yet because the case has stayed pending a Supreme Court decision on an unrelated aspect of the TCPA. But this is just something to be aware of. There are privacy issues related to class actions that are unique to the cannabis space and that courts haven't ruled on yet. Okay, I will pass it on to Tony now.
Next slide, please. Thanks. So we're going to talk for a few minutes here about the question of whether cannabis contracts are enforceable. And the answer to that question might turn on whether you're in federal court or state court. In federal court, the answer to that question is still a little bit unclear. As you may know, there is a federal statute called the Federal Controlled Substances Act, which prohibits the production, distribution, and sale of marijuana. And last August, in federal court in the state of Washington, a federal judge dismissed claims by a partner in a cannabis growing business because of the Federal Controlled Substances Act. That was a case where the plaintiff had been promised a 30% ownership interest in this business. He had helped build the business. And at some point, his 30% ownership interest was never delivered to him, and he never got any of the revenue or profits from the business. And so he sued, seeking both specific performance that he's entitled to his 30% and also to get past and future profits. The defendants immediately moved to dismiss the case, arguing that their agreement was not enforceable because of the Federal Controlled Substances Act, because a federal court cannot enforce a contract that is in violation of federal law. And the judge agreed. The judge said awarding plaintiff an ownership interest in or profits from this business contravenes federal law, and the judge granted the motion to dismiss. Now, there was one thing kind of unique about this case, which is that in the state of Washington, which was one of the first states that actually legalized cannabis, you cannot own a cannabis business if you have a criminal record. And this particular plaintiff did have a criminal record, and so he would not have qualified to be an owner of a cannabis business even under state law. And so arguably that makes this case a little bit of an anomaly, although when you read the court's decision, the portion of it that talks about federal law is in no way dependent on the fact that the plaintiff was also unqualified to own a cannabis business in Washington. I mean, the court's ruling was pretty clear that a federal court, according to this judge, simply cannot enforce an agreement that violates federal law. Next slide, please. So there have been a few other cases in which this question has come up in federal court, and judges have found ways to avoid actually having to address this issue head on. For example, in December of last year, also in the Western District of Washington, but a different judge, was faced with another case that presented this question of whether a cannabis contract can be enforced in federal court. And that was a case where a plaintiff sought to enforce an option agreement that would have allowed him to purchase the defendant's business if certain licenses were granted. And the licenses were granted. The plaintiff tried to exercise the option. The defendant didn't allow the option to be exercised, and so the plaintiff filed suit to enforce this agreement. And the defendant moved to dismiss, arguing that the agreement was contrary to federal law. Now, in this case, the judge, rather than addressing this conflict between federal law and Washington state law, sort of punted. The judge relied on federal abstention doctrine to remand the case back to state court. The judge basically said, this is an issue that needs to be worked out by state court in the state of Washington. So I'm not gonna deal with this now. And the judge remanded the case down to the state court. And then in the Williams case, also from last year, which is from right here in the Northern District of California, this case is actually a TCPA class action against ease, probably the same case that Cynthia was referring to earlier. In that case, it was a TCPA class action against ease, and ease made a motion to enforce, I should say a motion to compel arbitration based on an arbitration clause and class action waiver set forth in the terms of service that the plaintiff, who was simply an ease customer, had agreed to when he signed up for the service. And interestingly, in this case, the plaintiff actually argued in response to the motion to compel arbitration that the terms of service were illegal under federal law. So this was kind of an unusual situation where you have a plaintiff in a cannabis case arguing that a cannabis-related contract is unenforceable under federal law. Usually it's the plaintiff who wants to enforce the agreement. But here the plaintiff was actually using that argument as a defensive measure to try to avoid being put into arbitration and basically waive the ability to bring a class action. And so Judge Donato granted the motion to compel arbitration, and in doing so really avoided having to address this conflict between federal law and state law, because in this case, the state law was California. California, obviously now, we have legalized cannabis. Judge Donato relied on the Federal Arbitration Act, which provides that the provision in a contract related to arbitration, that is the arbitration clause, is actually severable from the rest of the contract. And even if the rest of the contract is ultimately decided to be determined to be void, the arbitration clause itself is still enforceable. And this was an arbitration clause that actually delegated questions of enforceability to the arbitrator. So Judge Donato just pushed the whole thing to the arbitrator and avoided having to address this conflict between federal law and state law regarding the enforceability of cannabis contracts. Next slide, please. So if you were in California state court and not in federal court, in all likelihood, contracts related to cannabis businesses are enforceable. And the reason is the California legislature passed a statute that became effective in January of 2019. Civil Code section 1550.5, and this is what it provides. Basically provides that notwithstanding any other laws, state or federal, commercial activity relating to medicinal or adult use cannabis that is conducted in compliance with California law is considered, among other things, to be a lawful object of a contract. So there has not yet been any California published case law interpreting this provision. I don't know whether any trial courts in the California state court system have addressed this provision yet, because those opinions are not published. But it's my expectation that eventually there will be published appellate court case law in California that confirms that in California, cannabis contracts are lawful, because the legislature has made quite clear in this statute that that's the intent. Next slide, please. So I want to talk just a minute about partnership and investor disputes. I've seen these come up a number of times over the years in the cannabis space. Usually these are disputes between people who enter into a business relationship together to start or run a cannabis business, or maybe it's an investor operator arrangement where someone is investing, someone else is going to operate the business. And the common thread that I have seen that leads to disputes is simply poorly drafted agreements. And I've seen this a number of times where agreements are drafted, usually not by lawyers, and they're not written very clearly, and they result in disputes. I expect as the industry gets more sophisticated, we'll probably see less of this, but this is a problem that I've seen over and over again. Just a few examples of the types of things I've seen include one dispute where the contract between an investor and a dispensary company was set forth in a one-page term sheet accompanied by nothing more than a few semi-corroborating emails. Another dispute was one I handled where my client was an entrepreneur who had discussions with an investor about investing possibly 6 to 7 figures in a business operation that was developing dispensaries around the state. And my client had drafted on his own, he was not a lawyer, a contract that was supposed to be simply for an earnest money payment of $1,000 by this prospective investor that basically would give this prospective investor the right to make a future investment in the business that was going to be subject to subsequent agreements and a subsequent closing. Now, ultimately, their relationship fell apart, and this prospective investor then relied on this poorly drafted language to argue that he had actually bought half of this company for $1,000, and he filed a demand for arbitration, making that argument. And then lastly, there are simply oral agreements. It's not uncommon, especially in this space, to see parties trying to enforce oral agreements. For the non-lawyers who are on this call, you may not know this, or maybe you do, but in general, subject to certain exceptions, contracts do not have to be written to be enforceable. It's one of the first things you learn in law school, and it's contrary to what I think a lot of people otherwise might think. The problem with oral contracts, though, is they're a lot harder to prove than written contracts, and you often end up in he said, she said scenarios, and so written contracts in general are much more advisable. Next slide, please. So I have a few very practical best practices and tips for addressing these issues. The first is document agreements in writing. Make your agreements in writing. Don't rely on handshakes. Don't rely on oral agreements or oral promises. Write your agreements down. Secondly, hire lawyers to help you draft agreements. It's very precarious to have lay people drafting agreements because I've seen it over and over again. It often leads to bad outcomes. Third, include an agreement to arbitrate or agree to venue any disputes in California state court. And the reason to do one of those two things is to avoid this problem of federal courts possibly not enforcing cannabis agreements. Now, I actually think that arbitration is probably the safest place to be because an arbitrator is not going to have any concern about representing the state or the people or the judiciary or anything like that. So whereas a state court judge might have some of those concerns in mind, and so might have some hesitation about enforcing an agreement that violates federal law. I think it's unlikely that that would be the case in California state court, given the strength of the statute we looked at a few minutes ago. But to me, arbitration is probably the safest place to be if you want to ensure that your cannabis agreements will be enforced. And then lastly, agree that California state law governs, because California state law is very protective, as we saw, of the enforceability of cannabis agreements. So I'm going to turn it back over now to Cynthia to talk about a few additional topics.
Thank you, Tony. So unfair competition claims. California has a law known as the Unfair Competition Law, or California Business and Professions Code, Section 7200. It is a frequent it's a frequently brought claim because it's a very broad type of claim, and it can be used to address countless situations. The statute provides remedies for unlawful, unfair, or fraudulent business acts or practices. And the purpose is to protect both consumers and competitors by promoting fair competition in commercial markets for goods and services. And as I said, it's broad, sweeping language, so, and it's intended that way to give courts broad, equitable powers to remedy violations. So if there's an allegation that something is unlawful or unfair, that is usually sufficient to state a claim for a violation of the UCL, and often these claims get past the initial pleading stages because they're just so easy to plead. Proposition 64, which passed a number of years ago, limited the scope of the UCL so that only certain people could bring claims. It used to be that anyone could witness a violation of a law and bring a claim saying, you know, this entity is violating X law or X regulation, and they could file a suit and extract money in a settlement. Now there's a standing requirement that a person has to have been injured in fact and lost money or property as a result of the unfair competition. So in theory, this limits the availability of UCL claims. Next slide. So there was an interesting case filed last year between by a company operating in the cannabis industry, Urban Industries, against Ease Technologies, which is the same cannabis delivery app that has shown up in previous parts of this presentation. And Urban alleged in its complaint that Ease had violated the UCL by allowing individuals to make cannabis purchases through its app using credit cards. Because cannabis is illegal under federal law, most credit card companies do not allow their credit cards, their payment processing systems, to be used to purchase cannabis. Urban alleged that Ease was essentially lying to credit card companies and perpetrating this scheme to allow credit card payments. Next slide. So Ease demurred, filed a demur, and challenged the claims. They had a few different arguments. The first argument was a standing argument. They said that, even if those representations were, even if the allegations are true, which you have to assume that they're true at the initial stage of the case, even if they're true, Urban was not harmed by Ease's representations to third-party credit card processors. And so Urban did not have standing to bring this claim. Ease also, upon the filing of the suit, changed its policy related to credit card payments and said that the court could take judicial notice of the system by which it made facilitated transactions, and that the system had clearly changed and the complaint was moot. They also made an argument that what Urban had alleged wasn't actually a crime, and that the doctrine of judicial abstention barred the claim. Essentially, they were asking the court to say, look, this case involves very complicated issues. Cannabis is legal in California. It's illegal under federal law. This makes it very difficult to operate, and we think you should just dismiss this case because it involves difficult questions of that where there's a conflict between state and federal law. Next slide. So the court overruled the demur. The court found that Urban did have standing to challenge Ease's actions because it alleged that it had been harmed as a competitor by Ease's practices. So basically what Urban alleged was, we operate under the law and we don't accept credit card payments, and because of that, Ease is unfairly competing. It's what they said. They said that Ease was violating the law and making it harder for them to operate. So the court said that was sufficient to establish standing. The court also denied or overruled the demurrer on mootness because there was still a dispute over whether EASE's changes to its policy were sufficient. And then the court also found that judicial abstention was not required because this did not require the court to determine any conflict between state and federal law. All it had to do was determine whether EASE's anti-competitive conduct harmed Urban. Next slide. So it's know that this type of claim is out there. There's really not much you can do from a practical matter to avoid this type of claim. You're not in, competitors aren't typically in business relationships or contractual relationships with each other. So this is not something that you can contract your way out of, unlike some of the examples of types of cases we mentioned earlier. But work with counsel to review your compliance with applicable laws and regulations, and make sure you're comfortable with your level of compliance given the risk that's out there, and develop an internal system to make sure that your employees and anybody who has control over your operations is complying with applicable laws and regulations. EASE had argued in its demurrer that a finding that Urban had standing to challenge EASE's conduct would open the floodgates for any competitor to manufacture standing by suing another competitor for any perceived wrongdoing, even small acts of noncompliance. And as long as they could allege that this gave their competitor a competitive advantage, and the court denied that, so that it does leave open the potential that competitors can police each other and extract money in settlements. So know that this is out there as another risk to your business, and work with counsel to make sure that you're doing what you can to comply with applicable laws and regulations. So this is the end of the presentation portion of the CLE, and now if there are any questions, we're happy to open it up to questions. You can use the chat feature, and we'll give you, a minute, and if not, I think we're gonna break out into breakout rooms, but if anybody has a question, you can speak up or use the chat function.